Dean Darlene Barberabe, Senator Robin Padilla, former Senate President Franklin Drilon, retired Associate Justice Conchita Carpio Morales, Commissioner Rene Sarmiento, my professors in the UP College of Law, non-teaching staff, guests, students, good afternoon. I am Isabel Zamora from Batch 2008, Block C, and it is my honor to once again be in the hallowed halls of the University of the Philippines College of Law, albeit in a different and fancier location. Never in my life did I think that I would speak in front of my professors or be chosen as a prosecutor in an impeachment case, as I always regarded myself as a simple girl. The role of being a prosecutor was offered to me on our last week of sessions, and I accepted the offer for several reasons. First, I was asked if I wanted to do something for the country. Second, as vice chairperson and an active member of the Committee on Justice in Congress, I believe that it is my duty to see the complaint through. Third, I was told that they needed someone who was matalino, mabait, at maganda. So I said, hindi naman. I initially had doubts after I was nominated, as I thought I was not a great trial lawyer. But sabi nga, para ito sa bayan. I was tasked by my friends and Congress colleagues from UP Law and UP to wear something maroon on the first day and to raise the flag of UP high. I am both excited and anxious about my new task. I brought out my highlighters and Post-its the following day and started reading. It brings back tons of memories from law school. I take this opportunity to mention a few aspects about the case. The complaint was culmination of a meticulous, transparent, and televised fact-finding effort of the House of Representatives. Certain matters, in fact, arose during the budget deliberations in 2023. Copies of the complaint were circulated to the members, and in fact, on the first circulation, I was already able to read the articles. Some members voiced their opinions on the matter. 215 members signed the complaint. The House prosecution will show that Vice President Duterte, since her assumption to office, has repeatedly, egregiously, and grossly violated her solemn oath and pursued actions that amount to culpable violations of the Constitution, flagrant betrayals of public trust, graft and corruption, and other high crimes. In particular, Vice President Duterte committed the following. She contracted an assassin and plotted to murder the President, the First Lady, and the Speaker of the House. She misused and malversed confidential funds appropriated for the office of the Vice President and the Department of Education. She disbursed or gave away monies amounting to graft and corruption, among others. The House prosecution has been meeting and preparing for trial to commence, as we believe that there is no other interpretation to the provision in the Constitution that trial shall forthwith proceed. I have so far been able to gather a lot of know-how, insights, and intelligence from the other panelists today and my professors today. I am extremely grateful for this opportunity, and I thank Dean Barberabe and all of you for bringing me back to the university that I love dearly. Thank you.
Thank you, Congresswoman Zamora. I understand that Attorney Season also has a few remarks.
Dean Darlene Marie Barberabe, the Senator Robin Padilla, retired Supreme Court Associate Justice Honorable Antonio T. Carpio, former Senate President Franklin M. Drilon, retired Associate Justice Honorable Conchita Carpio Morales, Honorable Rene V. Sarmiento, Attorney Ramon Esguerra, Associate Professor Gwen Grecia de Vera, Assistant Professor Theodore Te, Congresswoman Isabel Maria J. Zamora, Attorney Fina Bernadette A. de la Cuesta Tantuico, and my senior partner in Fortune Nervasa and Salazar, Attorney Gregorio Y. Nervasa II. Ladies and gentlemen, good afternoon. I would like to thank the UP College of Law, Justice George A. Malco Memorial Foundation, Inc., in partnership with the Philippine Law Journal, for the invitation to join this forum today that aims to encourage meaningful conversations on the emerging issues in impeachment, especially since we come to this forum as counsel for the Vice President, whom we know is now the subject of impeachment efforts. We appreciate the opportunity given to partake in today's discussion and listen to perspectives from which we could all draw some insights that hopefully would enrich the dialogue and our understanding, as well as of the public, about the impeachment process. The other night, I was reading a keynote speech that was delivered by the late good Senator Miriam Defensor Santiago in 2012, or 13 years ago. This was delivered before an annual convention of a Society of Doctors and Physicians. Now, in that speech, she cited the fundamental book on the topic of impeachment, authored by Professor Charles Black, Jr. of Yale University, and summarized as well the thoughts that the latter had on the matter. According to the late senator, impeachment is a dreadful process. It inflicts a deep wound on the country. Now, Professor Black, in his disposition in that book, described impeachment in this way, and I quote, "Removal by conviction on impeachment is a stunning penalty, the ruin of a life. Even more important, it unseats a person whom the people have deliberately chosen for that office." I understand, of course, that many who had come to this forum may probably already had formed their own opinions. This is but natural in a democratic country that values and encourages free speech. But I agree, it is a stunning penalty. It is a dreadful process. It ruins a life. In fact, I can even go one step further and state the reality that long before the impeachment process has begun, a life is already ruined by accusations made public and with the amount of heavy criticisms made for public consumption without the benefit yet of a trial. And perhaps that is the significance of having this forum today, in that we are reminded that despite our personal convictions and or opinions on issues surrounding the current impeachment efforts against the Vice President. Impeachment remains a serious constitutional mechanism that must be done only in the manner permitted by no less than our Constitution and the standards it had set therefore, in accordance with principles of fair play and the rule of law. I am hopeful that this forum would contribute to elevating the discussion among our people. Again, good afternoon at maraming salamat po.
Yeah, thank you for that question. First, I'd like to say that, as pointed out by Senator Drilon, should the Senate, in drafting its rules on impeachment, make the rules on evidence suppletorily applicable, then yes, the rules will apply. My point really was that we should not over-judicialize the proceedings, insisting on a strict application of the rules on evidence to the point of excluding what should otherwise be relevant to an inquiry into the sole issue of whether the public official should continue in office or not. Now, that formulation of the issue also addresses the question of whether rights are at the heart of the application of the rules. While I agree with you that the rules on evidence are intended really to protect rights, particularly due process rights in court proceedings. But again, and I guess we will go back to this over and over again, the impeachment proceedings are not court proceedings. The public official who is impeached is not an accused in the sense of a criminal case. And therefore, the rights of the accused are not implicated here. In fact, that may even be an open question. For example, self-incrimination, right? Could that actually be invoked in relation to, a question of a senator judge, right? Should, for example, the public official voluntarily appear and give testimony? And should the senator judge ask a question of the public official where the answer of the public official may tend to incriminate him or himself or herself, could the public official actually invoke the right against self-incrimination in an impeachment trial? I think that was the only point I was making, that we should not over-judicialize, because what I'm looking at in terms of the impeachment inquiry is really the fitness of the impeached official to continue serving, considering the gravity of the offenses that are levied against that official, and should they be proven true. Now, again, we do not have a constitutional presumption of innocence, as it were, in that particular proceeding, because it is not a criminal case. And therefore, we go back to how the Senate would formulate its rules, how the Senate would incorporate, for example, the rights of the accused, as it were. Should the Senate say in its rules, and I post this in the speculative because we don't have a copy of the rules yet, the Senate has not come up with its rules. Should the Senate say the rights of the accused in criminal trials are applicable, right? And therefore, should the senator judge pose a question that may tend to incriminate the impeached public official, then the impeached public official can say, I refuse to answer on the ground that it will incriminate me. And the senator judge could not be able to ask that question. But again, I do appreciate the question, because yes, I agree, the rules on evidence are there to give us that protection, and I would be the last person to say that we forego those protections. But again, I stress that the impeachment trial is not an ordinary trial. It's not a criminal trial. It's not a civil trial. It's not even an administrative trial. It's sui generis. It is of its own class. And therefore, there is a huge discretion on the part of the Senate to craft those rules. the burden, the responsibility, I think, right, is on the Senate. And I'm hoping that the Senate will be able to come up with a set of rules that will really address questions like those, right? But thank you for your question.